My uncle said it with the confidence of a man who had never once been wrong in a room he controlled. He looked at the probate judge, adjusted his jacket, and said that I was emotionally unstable, financially illiterate, and wholly unequipped to manage an inheritance of this size. He said my grandmother had loved me, but love was not the same as judgment. He said the estate deserved stewardship, not sentiment. He said all of this clearly, slowly, and on the record. Then my attorney opened her file. And the first document she placed in front of the judge was a list of every asset my uncle believed he owned. I say believed, because 14 months ago, quietly, legally, and without a single phone call to anyone in my family, I had become the lien holder, the majority creditor, and in 2 specific cases, the outright owner of the things on that list. My uncle had spent 40 minutes telling a court I was incompetent to inherit. He had no idea he had been paying me for over a year. Before I tell you what my attorney read out loud in that courtroom, and what my uncle's face did when she got to page 3, drop a comment and tell me where you're watching from. Because this story travels, and I want to know how far. My name is Claire. I am 33 years old. To my family, I am the quiet one. The granddaughter who stayed close to home, while everyone else built careers in cities with better zip codes. The one who visited my grandmother every Sunday, and reorganized her medication schedule, and drove her to doctor's appointments, and sat with her through the long, slow afternoons of her final years. To the 11 commercial tenants currently paying rent into accounts I control, I am their landlord. To the 3 private lenders whose notes I acquired over the past 2 years, I am their creditor. To the Delaware holding company that my attorney structured with the kind of careful, invisible precision that does not appear in casual conversation, I am the sole managing member. I did not inherit any of this. I built it quietly, methodically, the way you build something when you have learned that the people around you are not paying attention, and you have decided that their inattention is your advantage, not your limitation. My uncle's name is Robert. Robert had been paying rent on his law firm's office suite for 19 months. He had never once asked who owned the building. To understand the courtroom, you have to understand the family. My grandmother, Eleanor, was the kind of woman who built things quietly and outlasted everyone who underestimated her. She had started with a single rental property in 1974, a small duplex on the east side of the city that everyone told her was in the wrong neighborhood. She bought it anyway. Then another. Then a small commercial strip. Then a warehouse she converted into affordable studio spaces for artists and small businesses. By the time I was born, Eleanor owned 11 properties. By the time I was old enough to understand what that meant, she had taught me how to read a lease, how to evaluate a cap rate, and how to spot a maintenance contractor who was padding his invoices. She taught me these things on Sunday afternoons while the rest of the family was elsewhere. My Uncle Robert had spent those same years becoming a family law attorney with a good reputation and an expensive office, and the particular confidence of a man who has confused proximity to money with the actual understanding of it. He managed Eleanor's legal paperwork. He drafted her leases. He filed her annual property disclosures. He knew the shape of her estate better than anyone in the family. What he did not know was what Eleanor had been doing separately, quietly. In the years after my grandfather passed, and the family began circling her assets the way people circle things they expect to inherit, Eleanor had begun transferring properties. Not out of the family. Not to charities. Not anywhere dramatic, to me. 1 property in 2019. 2 more in 2021. Commercial note in early 2022. Each transfer properly documented, properly filed, properly disclosed in the county recorder's office where anyone who looked would find it immediately. Robert never looked. He was managing her estate. He was handling her legal affairs. He was the family's self-appointed expert on Eleanor's financial life. He never once pulled the county recorder's records on his own client. Eleanor passed in March. She was 84 years old, and she died on a Sunday afternoon, which she would have found appropriate. She left a will. The will was clear. The remaining estate, 3 properties, a brokerage account, and the contents of the family home, was to be divided equally among her 4 grandchildren. Robert filed a petition with the probate court 6 days later. He argued that the will was valid, but that the estate required professional oversight given the complexity of the assets, and the, in his words, varying levels of financial sophistication among the beneficiaries. He proposed himself as estate administrator. He noted specifically that his niece Claire, that is me, had no professional financial background, no demonstrated experience managing real estate assets, and had, in his assessment, spent the last several years in a caretaking role that, while admirable, did not constitute relevant expertise. He filed this petition on a Tuesday. On Wednesday, I called my attorney. My attorney's name is Miriam. Miriam had been referred to me 3 years ago by a commercial real estate broker who described her as the kind of attorney who reads every document twice and never walks into a room without knowing exactly what is in every other room connected to it. She had structured every acquisition I had made since 2021. She knew my holding company, my creditor positions, my ownership records. She knew, specifically, that my uncle's law firm had been leasing its office suite from a building I had acquired through my Delaware entity 14 months ago. She also knew that Robert had personally guaranteed the lease. When I told her about the probate petition, she was quiet for a moment. A specific quiet of a person who is not surprised, but is selecting the right response from several available options. She said, "He filed this without pulling your county records." I said yes. She said, "He listed you as financially unsophisticated in a court filing." I said yes. She said, "Claire, I need you to give me 10 days. I gave her 10 days. What Miriam did in those 10 days was what she always did. She read everything. She pulled every public record connected to every asset Robert had listed in his petition. She cross-referenced his property holdings with my creditor positions. She documented the lease on his office suite, the personal guarantee, the payment history, the ownership chain that led cleanly and traceable from the building's address back to my Delaware entity back to me. She also found something I had not known. Robert had filed the probate petition listing 3 of Aliner's properties as estate assets. 2 of those properties had already been transferred to me in 2021. They were not estate assets. They were mine. He had either not checked the county records before filing, which was negligent, or he had checked and filed anyway, which was something else entirely. Miriam noted this in her response brief, with the careful, measured language of someone who understands that the most devastating observations do not require emphasis. The probate hearing was on a Thursday morning. The courtroom was smaller than I expected. Wood paneling, fluorescent lighting, the particular stillness of a room where important things happen without drama. The judge was a woman in her 60s with the expression of someone who has heard every version of every family dispute and has long since stopped being surprised by any of them. Robert arrived with 2 associates from his firm. He was wearing the suit he wore to important things, the charcoal one with the subtle pinstripe. He had a leather briefcase that I recognized from family Christmases. He nodded at me when he came in, the specific nod of a man who believes he is being generous. Miriam sat beside me. She had a single folder. Robert's attorney, he had hired outside counsel, which I noted, presented the petition first. He was thorough and confident. He outlined the estate assets, the proposed administrative structure, Robert's qualifications, and his concerns about the, again, varying levels of financial sophistication among the beneficiaries. He spent approximately 4 minutes on me specifically. He mentioned my caretaking role. He mentioned my lack of formal financial credentials. He mentioned that in Robert's professional assessment, placing the estate under my co-management would introduce unnecessary risk. The judge listened. She made notes. Then Miriam stood up. She did not raise her voice. She never raises her voice. She has the particular stillness of someone who understands that volume is what you use when your evidence isn't sufficient. She said she would like to introduce several documents into the record before responding to the petition's characterizations. The judge said proceed. Miriam placed the first document on the table. The county recorder's transfer records for 412 Eastfield Avenue and 808 Commerce Row, 2 of the 3 properties Robert had listed as estate assets. She said these properties had been transferred to Claire Aliner Whitfield, that is my full name, Aliner for my grandmother, in March and September of 2021. They were not part of the estate. They were already mine. Robert's outside counsel leaned over and said something quietly to Robert. Robert's expression did not change, but his jaw moved in a way that suggested recalculation. Miriam placed the second document. The Delaware entity registration for Whitfield Holdings, LLC. Sole managing member, Claire Aliner Whitfield. Formation date, January 2020. She placed the third document. The acquisition record for 1400 Mercer Street, a 6-story commercial building in the financial district. Acquired by Whitfield Holdings, LLC, in November 2022. She paused. She said she would like to note for the record that 1400 Mercer Street was the current address of Holloway and Associates Family Law, Robert's firm. The room was quiet. The judge looked up from her notes. Miriam placed the fourth document. The lease agreement for Suite 400 at 1400 Mercer Street, signed by Robert Holloway personally, including a personal guarantee clause on page 7. Monthly rent, $14,200. Lease term, 3 years. Landlord of record, Whitfield Holdings, LLC. She placed the fifth document. 19 months of rent payment records. $14,200 per month. Paid reliably, and on time into an account controlled by Whitfield Holdings LLC. Controlled by me. My uncle had been my tenant for 19 months. He had stood in this courtroom 40 minutes ago and told a judge I was financially unsophisticated. He had written me a check for $14,200 11 days before this hearing. The judge set down her pen. She looked at Robert. She asked him whether he had been aware, at the time of filing, that 2 of the properties listed as estate assets had been transferred out of the estate in 2021. Robert's outside counsel started to speak. The judge looked at him briefly. He stopped. Robert said he had relied on the estate inventory he had maintained as a liener's legal representative. The judge asked whether that inventory had been cross-referenced with county recorder records prior to filing. Robert said the process had been, he used the word expedited. The judge wrote something down. She asked Miriam whether Whitfield Holdings LLC had any other creditor positions relevant to the estate or its proposed administrator. Miriam said yes. She placed the 6th document, a promissory note, dated 14 months ago. Borrower, RH Capital Partners LLC, a holding entity registered to Robert Holloway. Lender, Whitfield Holdings LLC. Principal, $340,000. Secured against a commercial property Robert owned personally. He had borrowed $340,000 from my holding company 14 months ago through a private note transaction structured by a broker neither of us had told the other about. He had not known who the lender was. I had not known who the borrower was until Miriam found it during her 10 days of preparation. We had been in a creditor-debtor relationship for over a year. He had filed a petition calling me financially incompetent while being $340,000 in debt to my company. The judge looked at Robert for a long moment. She said she was going to take a brief recess. I want to tell you what happened in that recess because I think it matters more than the ruling. Robert came and sat beside me in the hallway outside the courtroom. Without his outside counsel. Without his associates. Just Robert in his charcoal pinstripe suit, looking like a man who had just walked into a building and discovered the floor plan was completely different from the one he had memorized. He said, I didn't know. I said, I know you didn't. He said, Alina never told me. I said, she told me. He was quiet for a moment. In the courtroom, he had been precise and prepared and confident. Out here, he looked like what he actually was, a man in his 60s who had spent 40 years being the smartest person in his family's room and had just discovered that the room had been quietly, patiently rearranged around him. He asked me why I hadn't said anything. Before the hearing. Before the petition. Before any of it. I thought about how to answer that honestly. I said that for as long as I could remember, my role in this family had been defined before I entered any conversation. I was the quiet one, the caretaker, the one who stayed close and asked for nothing and was therefore assumed to have nothing. I had spent years trying to correct that assumption through words and gotten nowhere. So I had stopped trying to correct it through words. He nodded slowly. Like a man doing arithmetic he didn't enjoy. The judge's ruling came 20 minutes later. The petition for Robert to serve as estate administrator was denied. The 2 properties he had listed as estate assets were formally recognized as my property, transferred legally and completely in 2021. The remaining estate would proceed through standard probate with an independent administrator appointed by the court. The note. The lease. Those were separate matters, civil and contractual, which Miriam and Robert's counsel would handle between them. On the way out of the courthouse, Miriam said to me, you know most people would have called him. Before it got here. Would have given him the chance to withdraw the petition. I said, I know. She said, why didn't you? I thought about my grandmother on a Sunday afternoon, teaching me how to read a lease at her kitchen table while the rest of the family was elsewhere. I thought about what she had said to me, once, near the end, when I had asked her why she had chosen to give the properties to me specifically. She had said, because you're the only one who ever asked how they worked. I said to Miriam, because he filed first. He put it on the record that I was incompetent. In a courtroom. On a Thursday. I thought the response should also be on the record. Miriam smiled. The small, precise smile of a woman who has been practicing law for 30 years and still occasionally encounters a client who surprises her. She said, it is. I drove home the long way. Past 1400 Mercer Street. I looked up at the 6th floor where Robert's firm occupied the corner suite with the view of the financial district that he had specifically requested when he signed the lease. I had approved that request. I had not known it was him. He had not known it was me. My grandmother would have found that funny. Not cruelly. Just in the way she found most things funny, with the quiet appreciation of someone who understood that the universe has a sense of irony that does not require our assistance, but occasionally accepts it. I went home. I made dinner. I called my cousin to let her know the hearing had gone well. She asked if I was okay. I said I was more than okay. I said I was exactly what my grandmother had always known I was. I just finally had it on the record.